Wrongful termination. Millions of Americans type those two words into a search bar every year, usually within days of being walked out of a building. Here's the uncomfortable truth. Most of them don't have a case. Being fired unfairly is not illegal in most of America. But here's the other truth, the one that matters. The people who do have a case usually don't know it. They wait too long, and they settle for a fraction of what the law says they're owed. So today, in plain English, what actually counts as wrongful termination? The telltale signs courts use to catch employers lying about the real reason. What happens if you were forced to quit instead of fired? What a real case is actually worth in dollars? And the 90-day deadline that quietly kills winning cases. Let's unlock your rights. Let's fix the definition first, because this word trips everyone up. In everyday English, wrongful sounds like it means unfair. In law, it means one specific thing. You were fired for a reason the law forbids. Not a harsh reason, not a stupid reason, a forbidden one. We covered the forbidden list in detail in our last video, so here it is in one breath. Discrimination over race, sex, pregnancy, religion, disability, or age 40 and up. Retaliation for reporting harassment, wage theft, or safety violations, punishing you for protected leave, jury duty, or refusing to break the law. And firing that breaks a contract or a clear promise. If the real reason behind your firing lives on that list, the law calls it wrongful, no matter what the paperwork says. And that phrase, the real reason, is where every one of these cases is won or lost. Now the myth busting, because knowing what doesn't count saves you months of chasing the wrong fight. Fired with no warning? In an at-will state, that alone is legal. Fired for a reason that's flat out wrong, the manager blamed you for someone else's mistake? Still usually legal. Passed over for the boss's golf buddy, managed by someone incompetent? Put on a performance plan you thought was garbage? Unfair, infuriating, and almost always lawful. No severance offered? Federal law doesn't require severance at all. A toxic workplace by itself, with no discrimination or retaliation underneath? The law mostly shrugs. Here's the pattern. The law doesn't referee bad management. It polices forbidden motives. So the question is never, was this fair? The question is, can I connect this firing to something on the forbidden list? If yes, keep watching, because the next section is how that connection gets proven. No employer admits a forbidden motive. They write performance, restructuring, not a culture fit. Courts know this, so the law looks for pretext, evidence that the official reason is a cover story. These are the classic tells. The shifting story. HR says performance. The unemployment office hears misconduct. The reference call says restructuring. Every new version helps you. The suspicious timing. Stellar reviews for 5 years. Then 2 write-ups in the 6 weeks after you announced a pregnancy or filed a complaint. The comparator. Someone outside your protected group did the same thing and kept their job. The skipped process. The handbook promises warnings and improvement plans, and you got none of it. And the eliminated job that wasn't, they cut your position, then quietly posted it under a new title a month later. None of these alone is a slam dunk. 2 or 3 together are how wrongful termination cases actually get won. Start writing down every one you can remember, with dates. Today. Now the trap almost nobody knows. What if you weren't fired? You quit because staying had become unbearable. The law calls that constructive discharge. If your employer made working conditions so intolerable that a reasonable person in your shoes would have felt forced to resign, and those conditions came from discrimination or retaliation, courts treat your resignation as a firing. Same claims, same remedies. The bar is high. A bad month, a demanding boss, a cold shoulder, not enough. Slashed hours after a harassment complaint. Demotion to humiliate you out the door. threats, and impossible conditions aimed at making you leave. That's the territory. 2 warnings. First, document the intolerable conditions before you resign, not after. Second, the deadline clock starts the day you give notice, not your last day, and not the day you get angry. If this is you, move fast. It wasn't a firing. It was a layoff. Layoffs are legal, but they come with 2 sets of rules employers love to skip. First, the WARN Act. If your company has 100 or more full-time employees, and it closes a site affecting 50 or more workers, or lays off 50 or more people making up a third of the workforce, or 500 people anywhere, it generally owes everyone 60 days of advance written notice. No notice? The penalty can be up to 60 days of back pay. Several states have their own mini-WARN laws that reach smaller layoffs. Second, the selection itself. A layoff is not a free pass to clean house. If the objective list somehow swept out the workers over 50, the pregnant employee, and the guy who just filed a safety complaint, that's a discrimination case wearing a layoff costume. Ask for the selection criteria in writing. And if you're over 40 and offered severance, remember from our last video, you get 21 days to think. Let's talk money, because you can sue means nothing without numbers. A winning wrongful termination case can recover back pay, every dollar of wages and benefits from the firing to the judgment. Front pay, future earnings while you get back on your feet. Compensatory damages for emotional distress and out-of-pocket harm. Punitive damages when the employer's conduct was malicious. And in most discrimination cases, your attorney's fees on top. Federal law does cap some of it. For compensatory plus punitive damages combined, the cap runs from $50,000 for employers with up to 100 employees, up to $300,000 for companies with more than 500. But hear this clearly. Back pay and front pay sit outside those caps. Many state laws have no caps at all, and age claims follow their own formula that can double your lost wages. That's why real settlements range from a few months' salary to life-changing numbers. The size of your case is mostly the strength of your evidence multiplied by your lost income. You control the first half. Here's how the road actually looks, so nobody can string you along. For discrimination or retaliation, you start by filing a charge with the EEOC or your state agency. 180 days, 300 in most states. You know this from last time. The agency may offer free mediation, investigate, or neither. Most charges end with a document called a notice of right to sue. That notice is not a rejection. Read that again. It's your ticket to court. But the moment you receive it, a brutal clock starts. 90 days to file your lawsuit. Miss it by a day, and even a strong case is usually gone forever. Courts enforce this one without mercy. And the honest timeline, from charge to resolution. Employment cases run months to a few years, which is exactly why most of them settle along the way. Your evidence file is what decides whether they settle cheap or settle right. I can't afford an employment lawyer. Good news. For cases like these, you mostly don't pay up front. Most employment attorneys take wrongful termination cases on contingency, typically a third to 40% of what they recover, and nothing if they lose. Consultations are usually free, and many will review a severance offer for a small flat fee. What makes a lawyer say yes? 3 things. A motive from the forbidden list, evidence of pretext like the tells from earlier, and deadlines that are still alive. Bring your timeline, your reviews, the shifting stories, and your pay records to the consult. Organized beats angry every time. If 3 lawyers pass, ask each one why. Sometimes the answer is your damages are small. And for pure unpaid wages, you already know the fix. Your state labor agency or small claims court. No lawyer needed. We built you a full guide on that. So, what does the law actually say about wrongful termination? Unfair isn't enough, but a forbidden motive changes everything. Pretext is how you prove it. Forced resignations can count. Layoffs have rules. The money is real, and so is the 90-day trap. Your path? Write the timeline while it's fresh. Collect the tells, shifting stories, timing, comparators. File your charge before 180 days. When the right to sue notice lands, treat 90 days like a fuse, not a suggestion. And talk to a contingency lawyer before you sign anything away. If you haven't seen it yet, watch our at-will employment guide next. It covers the first 48 hours after a firing and the money your employer owes you on the way out. And it pairs with this video like two halves of one playbook. Subscribe if this helped, because every week we take one right that powerful people hope you never read about, and we unlock it.